What types of questions can the police ask on a motor vehicle stop? Can I ask you if you have drugs in the car? Can I ask you if you have weapons in the car? What about your watch? Can we have a conversation about your watch? Can I ask you where you work? The answer is always going to be it depends. What's the purpose for my questioning? Is it tied to the officer safety mission associated with a motor vehicle stop? Is it tied to the traffic infraction? Or am I going on a fishing expedition trying to make an ordinary traffic violation into a bigger criminal investigation? And if the answer is part of the latter, the courts are going to probably suppress the questioning and look at it as an unlawful extension of the stop under U.S. v. Rodriguez. But here, in this case, they give us a really good takeaways and some guidance about how we should or should not conduct our line of questioning when we're actually doing a motor vehicle stop. This is another J. Harris Academy of Police Training Roll Call. I'm Joey Sperlazza, and the case that we're discussing today is the United States versus Raphael Ross. This is a U.S. Court of Appeals Third Circuit precedential opinion decided on August 19th, 2025. First, we have to look at the background. Rodriguez versus United States, 2015 case. Traffic stops must be limited to their mission, handling the traffic violation and ensuring officer safety. Unrelated questions that extend the stop require independent, reasonable suspicion. There is no de minimis exception. Even small extensions count as prolongations if unrelated to the mission. The Fourth Amendment permits conversation that furthers the stop's mission, including questions related to the processing of the infraction and officer safety, but it shuns inquiries that turn the stop into a roving criminal investigation, unless independently supported by reasonable suspicion. On January 15, 2021, Philadelphia Police Department officers Smart and Foreman were patrolling an area in South Philadelphia known for violent crime and narcotics sales. Around 7:30 p.m., the officers pulled over a car that had windows tinted in violation of state law. Ross was the driver. Smart explained the reason for the stop and requested the driver's documents. Ross produced expired insurance and the vehicle's registration cards and explained that he left his license at somebody's house. Smart reassured Ross that if everything checked out with his documents, he wouldn't be issued a ticket and would be on his way with just a warning. Ross exhibited signs of anxiety and nervousness, including shaking hands, stammering voice, quivering lips, heavy breathing, and a refusal to make eye contact. Ross fumbled and rummaged around the middle of the cabin and erratically moved his jacket around the car, shifting it from the passenger seat over to his lap and then positioning it over the center console. Ross claimed that he was looking for his license, but neither officer believed him as Ross already said he had left it at home. Nor did it appear as though he was looking for anything in the jacket, but was instead simply moving it around in an odd manner. Officer Smart described Ross as one of the most nervous individuals he had ever pulled over. Before going back to his patrol vehicle to verify Ross's information, Officer Smart complimented the Rolex watch that Ross was wearing and asked Ross where he worked. Ross thanked him and answered that he owned a home health aid business. Officer Smart returned to the patrol car to conduct records checks, while Officer Foreman walked over to the driver's side. In total, this initial interaction lasted between 1 to 3 minutes, with the watch and job exchange lasting around 5 seconds. Officer Smart ran the usual database checks to verify Ross's identity and license status. Those checks brought up Ross's lengthy rap sheet, including a recent arrest for firearm possession. Officer Smart phoned the arresting officer and learned that Ross had been caught with a gun after he resisted and fought police officers during a routine traffic stop. The colleague urged Smart to call for backup, and he took that advice. The database queries and call consumed roughly 5 to 7 minutes. Officer Foreman remained at the driver's side of the vehicle. She asked where he was coming from and where he was going. Ross continued to avoid eye contact, shake, stammer, and breathe heavily while reaching around the center console with his jacket. When Officer Foreman asked why he was nervous, Ross began fishing under the front seat. Twice, Officer Foreman told him to plant his hands on the steering wheel. Twice he ignored her, instead reaching around the interior of the car where Foreman could not see. Ross then tried opening the driver's side door until Officer Foreman wedged her body in its path. Officer Smart rejoined the scene and backup arrived. Smart ordered Ross out of the car and frisked him for weapons. Smart found a wad of cash in Ross's back pocket, which Ross claimed was for his grandfather's funeral. Smart and Foreman then frisked the front interior of the car for weapons and recovered a semi-automatic pistol and 136 packets of fentanyl and heroin hidden in the center console. Ross filed a motion to suppress, which was denied by the district court. He then pled guilty. Ross now appeals, arguing that the district court erred by denying his motion to suppress because the watch and job exchange violated the Fourth Amendment by unlawfully extending the traffic stop. The court decision and reasoning. Under U.S. v. Rodriguez, inquiries that further the stop's mission, when made with reasonable diligence, do not unreasonably prolong the stop and thus are permitted under the Fourth Amendment. In contrast, measures aimed at detecting evidence of criminal wrongdoing and other fishing expeditions fall outside the scope of the stop's mission of processing the ticket and ensuring roadway safety. At the moment an off-mission inquiry prolongs a stop, the officers must have developed reasonable suspicion of criminal activity independent of the traffic violation. There is no de minimis exception to the rule. Rodriguez's standard accommodates the on-ground realities of a roadside seizure for the acceptable length of a routine traffic stop and cannot be stated with mathematical precision. Ross does not challenge the initial stop, instead arguing that Smart impermissibly extended the scope and duration of the stop when he complimented Ross's Rolex and asked Ross what he did for a living. One of the things that I absolutely love in this particular case is how the court breaks down different types of inquiries and conversations and how they are permissible versus impermissible. And that's specifically what we get into right here. The court discussed several types of conversations. First, small talk. Pure small talk, encompassing conversation that carries no constitutional significance, social graces that are neither investigatory in nature nor meaningfully prolong the stop. They are customary cultural expectations and practices. Nothing in the Constitution requires officers to behave like robotic automatons or demand stony silence. Interaction-related inquiries. This includes questions aimed at assessing whether the driver is legally on the road and processing the ticket. This includes, among other things, requests for license, registration, and proof of insurance, questions about the traffic infraction, and context framing inquiries about the driver's travel history and plans. Employment questions may fall into this category, depending on the context. This court has held, for instance, an officer can ask questions about the driver's occupation to assess a driver's sobriety during a DUI stop. Safety-related inquiries. Officer and roadway safety is mission critical. Questions directly tied to officer safety, such as asking the driver whether there are any passengers in the car or if he has any weapons on him, are always permitted on officer safety grounds. Brief, casual questioning aimed at gauging risks or de-escalating a situation may also qualify as reasonable precautionary measures during traffic stops to ensure the safety of officers and others. Off-mission inquiries. Questions that cannot be reasonably characterized as relating to roadway safety or the traffic violation fall within this category. This includes inquiries designed to facilitate on-scene investigation into other crimes and to detect crime in general or drug trafficking in particular. Although our objective inquiry under Rodriguez is context dependent, certain questions would hardly serve any other purpose. United States v. Campbell. Do you have any counterfeit merchandise and have any dead bodies in your car? Were fairly obviously precisely the type of questions that Rodriguez prohibits. In U.S. v. Gomez, an officer detoured from the mission of the stop by asking the driver narcotics-related questions from the moment that the officer first approached the car. In U.S. v. Buzzard, depending on the facts of a stop, a question that appears off mission on its face may in fact promote safe completion of the stop and thus relate to the stop's mission. Diving deeper into buzzard, an officer's single question near the beginning of the stop, and it is key to note, near the beginning of the stop, is there anything illegal in the vehicle, was best understood as an inquiry about whether there was anything dangerous in the vehicle, and thus related to officer safety and the traffic stop's mission, because in that context, it was asked by a solo officer who was outnumbered during a late night stop in a high crime area, and both occupants exhibited abnormal behavior. Now, compare Buzzard to U.S. versus Gorman. Asking the driver if there was anything illegal in his car 20 minutes into the stop after a citation was processed and when the driver should have been free to go was an off-mission inquiry. In short, context matters when assessing roadside questioning. Employment questions, when deployed as a pretext to sniff out unrelated criminal activity, can veer into this investigative lane. Questions that initially appear unrelated to officer safety may nonetheless qualify as on-mission, safety-related inquiries when the officer has an articulable basis for safety concerns grounded in observable facts. The questions in context can be reasonably understood as relating to those safety concerns, such as an effort to diffuse tension, assess demeanor, determine the degree of caution needed, or evaluate whether the driver presents a threat. And the officer does not prolong the stop with unrelated follow-up inquiries once reassured. The watch and job exchange did not unlawfully prolong the stop. Ross exhibited clear signs of extreme anxiety and nervousness, including shaking hands, stammering voice, quivering lips, heavy breathing, profuse sweating, and a refusal to make eye contact. Officer Foreman testified that Ross was in the top 5 of how nervous someone could be. Something was off. Ross kept making abnormal hand movements, including erratically shifting his jacket across the seats and center console and fumbling around the interior of his car. His explanation for such movements, that he was looking for his license, was incongruous with both the earlier statements that he left it at home and his shifting of the jacket without checking the pockets. At this point, a reasonable officer will be concerned that Ross may have committed or may be about to commit a serious crime, was preparing to fight or flee, or was drunk, on drugs, armed, or some combination thereof. Officer Smart articulated a non-investigatory reason for his interaction, consistent with social custom. He, like many officers in this country, routinely used small talk to calm nervous and tense motorists. Officer Smart explained that he's a fan of watches and that he complimented Ross's Rolex because it was the first thing he noticed and he thought it provided a common ground of conversation. Viewing the watch conversation through a filter of common sense and ordinary human experience, it provided a natural entry point of conversation between two strangers. The follow-up question about employment was one a reasonable officer could believe would establish a rapport with the driver, diffuse tension, and provide important clues pertaining to safety, such as nervous or evasive responses. Neither officer asked any repetitive, intrusive, or in-depth questions after the brief exchange. Officer Smart did not use Ross's answer as a springboard to justify further inquiry or facilitate a detour into investigating unrelated crimes. Apparently satisfied that more precautions were necessary, Smart immediately returned to the business of completing the stop. The court ruled the watch and job exchange stayed within reasonable limits given the objective safety concerns. Officer Smart's compliment and single question is consistent with both the public's expectations regarding ordinary inquiries, incidental to traffic stops, and taking the least burdensome approach to ensure officer safety. The appeal is denied. In the classes I teach, it's always a hot topic as far as searching, seizing, and questioning that comes up during the course of a motor vehicle stop. I really love how they break down the different types of inquiries in this particular case. One of the key takeaways is looking at this line of questioning through the lens of a reasonable person. Would a reasonable person have felt that asking brief inquiries as to the type of watch that he had, what does he do for a living, did that appear to be a fishing expedition? And in this case, it absolutely wasn't. You have a very nervous person that the officer was trying to calm down, trying to establish some sort of a rapport with. And as you're having casual conversation, he's continuing to act nervous. He's continuing to hide his hands, reach under the seat after being told to put his hands up on the steering wheel. If you're a civilian watching this case, follow the officer's commands. We want you to go home safe the same way that we want to go home safe. If you're an officer watching this, understand that this line of questioning was permissible in this particular case because of all the circumstances that arose from this case. There was a lot of nervousness and a lot of articulable facts that are in this case that we don't see in some other cases. But one of the key takeaways I want us all to understand is the more that you are friendly with the occupants, the more that seems like casual banter going back and forth, the more likely it is that the court will find it as a line of permissible questioning. And for civilians, the more that you comply and you show us that this was an innocent mistake, the more likely we are to let you off with a warning. I personally don't write a lot of tickets. The enforcement aspect is only one piece that's tied to the mission of a motor vehicle stop. There could be education issues. Maybe you didn't know what the law was. There could even be engineering issues with respect to brush covering a stop sign. Maybe I need to contact the town and make sure that that brush gets removed from the stop sign. But again, as we look at this particular case very well demonstrates that line of permissible questioning. We just rolled out our new class, the Motor Vehicle Master Class. This class will ensure that you are getting everything from reasonable articulable suspicion to courtroom success. We will go over not only this case, not only questioning, but helping you guys understand when you have probable cause to search a car, when you have reasonable suspicion to frisk a car. What is that permissible line of questioning? Please check that out. Sign up for our other classes, such as the Legal Update, where we dive deep into all the recent court rulings. But until next time, again, I'm Joey Sperlazza. Stay safe and subscribe for more updates.
This podcast is brought to you by the J. Harris Academy of Police Training. J. Harris Academy of Police Training is based in New Jersey and provides law enforcement training services nationwide for promotional examinations, use of force, supervisory development, and other key areas within law enforcement. This podcast is utilized to discuss key topics occurring within the profession. The opinions and information provided is for entertainment purposes only. In an effort to provide this, we often purposely discuss opposite views and opinions to spark conversation and develop discussion points. The contents of the show and show notes are all copyrighted. All blog posts, podcasts, and show notes that are distributed to the public for free can be redistributed via hard copy or electronic copy for free, only if the J. Harris Academy of Police Training is included as the acknowledged author within the actual media that is redistributed. This entire disclaimer also applies to any guests or contributors to the podcast or blog. Under no circumstances shall the J. Harris Academy of Police Training, any guests, contributors to the podcast or blog, or any employees, associates, or affiliates of the company be responsible for damages arising from the use of the information provided.